Welcome to the 2021 edition of the Legal Ethics Year in Review, news you can use. I'm Lucian Pera. I'm a partner in the law firm of Adams and Reese, LLP. Happy to be with you today. Happy to have you with us today. I will say I'm thrilled there's so many people with us. I guess I want to say I'm not going to let my head get too inflated by that because I understand the way end of year deadlines and ethics requirements deadlines work. So I love y'all and I'm happy to see you here. But I understand some of you just needed an ethics hour. So hopefully we can build up from that and make it slightly more entertaining than your average ethics hour. We'll see. But I've been doing this for about 5 years now, 5 or 6 years now. And so our topic is pretty simple. It's the top 10 developments of the last year in ethics and lawyering. One other thing you should know before we get going, which is materials. All of the sources, opinions, and cases and such, and a few articles I'm going to talk about here today or that are mentioned in the slides are posted. They are posted in one big zip file with, I think, 10 PDFs in it, 10 PDFs for each of the 10 items we're going to cover, plus the PowerPoint is in there too. And that zip file should be either itself or a URL to it. You can just copy this one if you want, or you should be able to get to it in resources as you're watching the video here today. The other thing is questions. Questions should be interesting. I hope we can make that work. Since there's only one of me, I've got help in the background here trying to send some of them to me. But please post your questions in the Q&A, and I'll get to them if I can get to them. If I don't get to them, then I will try to follow up afterwards and get with you. So with that, let's go on to our first item, which is, of course, number 10 on lawyer mobility. Lawyer mobility is, if anything, during the pandemic has increased at various points, particularly as we thought we were coming out of it. It increased a decent amount. And of course, I'm talking about mobility from practice setting to practice setting, going in-house, coming out, going from one firm to another. I have a couple of items there this year that I wanted to mention. Let's start with a New York State Bar ethics opinion. In some sense, perhaps a sort of pedestrian question, but the question is, to what extent a lawyer who leaves a law firm solicit former clients that she worked for at her old firm? The fact situation here was, I believe it was a wills and estates law firm in New York, and there were about 1,100 clients that needed to be told of this particular lawyer's departure, and they got along okay in the departure, apparently, because they sent a joint letter from the firm and the departed lawyer to all those 1,100 clients saying, departed lawyer has left to pursue a practice elsewhere. Please let us know if you want to go with her, to stay with us, or to hire somebody new. Well, the problem was that after a certain period after she left, it was crickets. There was nothing from the old firm. They didn't tell her who had said they wanted to go with her or who wanted to stay. They didn't send client files. And I gather, reading between the lines of the opinion, she was pulling her hair out over this. She asked the New York State Bar Ethics Committee, well, can I contact those 1,100 clients? And the answer is reasonably clear, if not obvious. Yes, of course she can. She has to be truthful and non-misleading and all that. But the old firm doesn't have any ability to simply shut her down in terms of not providing her that information. And yes, she can, once she leaves the firm, then having no duty to the old firm of a fiduciary nature, she can compete for that work, and she can certainly, without it being prohibited solicitation, she can certainly ask for the business of clients she worked on while at the firm. So sort of simple answer, but it is a reminder that the best solution to problems in the departing of a lawyer from a law firm is, frankly, good grown-up adult communication between the departing lawyer and the departed firm. The California Lawyers Association, that is actually, you may know that in California, the state bar, the integrated bar, the mandatory one, split into two parts not that long ago. And there resulted a voluntary bar called the California Lawyers Association, which issued this opinion, and the state bar, which continues to issue opinions. So I'm not sure they're going to have twice as many opinions. They've typically issued good opinions. This, though, is number one of the California Lawyers Association's forthcoming stream of opinions. And I mention it here because there are not a huge number of opinions out there on what constitutes an effective screen. Screen, you may know, is it's the sort of the newer term that some of us old people have remembered from being a Chinese wall. But the notion being you segregate one lawyer in a firm, or it can be a paralegal or whatever, from other lawyers with respect to one case, for example. Screening applies in some settings with government lawyers as they move in and out of government. It can even apply in-house. but it certainly applies in private practice, moving from one setting to another. And it also applies, by the way, in the least known rule there is that we have, Rule 118, which is about prospective clients, how we deal with situations where a client attempts to hire us, thinks about hiring us, but doesn't ultimately hire us. That same screening concept can work there. And the concept of what a screen is and how it works is pretty much the same across that wide spectrum, across the rules. So, for example, and by the way, I should also add two other areas where it's used. One is by consent. A client can condition its consent to waive a conflict of interest on screening. And it's the terms of screening can be by consent as well. You can shape those, but in any event, it also can be an alternative remedy from a court. So screening pops up in lots of different places. This opinion is about what makes a screen effective, what makes it ethical. All right. So there's several, as they say under their rule, mandatory elements of screening. There is, it has to be timely. You can't wait for months after the lawyer who is tainted, as they say, is at your firm to screen them. You got to do it as soon as you can, usually before they start, if you know about the problem. Two, there can't be fee sharing from the screened case, so to speak, with the tainted lawyer. And then you have to give notice to affected clients. And the opinion talks about those. But the opinion also talks about that context matters and that there are lots of facts that matter. And they run through a bunch of them. This is an opinion that runs for about 10 pages. And it usefully talks about geography. Are the two sets of lawyers you're trying to separate in different cities or in different offices? It talks about technology. These days, document management systems are, many firms, if not most firms, have something like a document management system. And anything that's really has the name document management system usually has the functionality to lock certain people out of certain files, which is really helpful if you're screening somebody, because then not only can you lock them out, but you can prove it, which is very useful. And then there's also some discussion in the opinion about the sensitivity of some of the information and how that may be a factor. So it's a helpful opinion. Sure, it's not binding in every state, but it's useful. And frankly, it's the latest, most comprehensive treatment of what makes a good screen. The third case we've got there is the Governo case. There are not many pieces of litigation, not many lawsuits between departed firms and departing lawyers. And the reason is mostly because clients get to pick. It's their choice. And so the notion that you could prove up damages that somebody, even if they violated the ethics rule when they left your law firm, you could prove up damages. Well, good luck with that, because of course the client makes that decision, and that usually cuts off causation. In any event, this is a lawsuit between the departed firm and several departed lawyers. These, I think, three lawyers decided that what they were going to do was, and I think it was a plaintiff's firm in a particular practice area, they decided they wanted to own the firm, and they wanted to buy it from the boss. It was a solo practitioner owned by one lawyer. And so they decided they were going to make an offer, jointly together, make an offer to the owner and say, we want to buy the firm and then carry on the practice. And it sounds like the way the opinion reads to me, they wanted him gone, which is fine. And that would have been fine. But what they also did before they left and before they made the offer / ultimatum was they ripped and downloaded many megabytes or gigabytes, I'm not sure how many, of data that were all about how they practiced. Forms and practice aids of various kinds. It was the whole way the firm had chosen and developed to do this kind of work that, frankly, when they took it and then used it after they left, because the boss turned them down on their offer, made starting a practice and competing way more effective. It was the guts of how this firm did business. And it was certainly some kind of work product and maybe even trade secret. In any event, there's a colorful part of the case where they say that one of the three malefactors actually took the small hard drive and put it in a gym bag to carry it out of the firm. So anyway, not that colorful, but then it's an ethics case. So, what are you going to do? In any event, they got a verdict. The departed firm got a verdict in 6 figures against the departed lawyers, largely under the little FTC Act, the Unfair or Deceptive Trade Practices Act. But one thing they didn't get was the ability, according to a ruling by the judge, to prove up this bad conduct before these lawyers left, because of the notion present in a lot of states' law that intra-company misconduct was like an intra-company conspiracy. It wasn't recognized. It's Supreme Court of Massachusetts, Supreme Judicial Court of Massachusetts said, nope, that rule is gone. And you can try this again, and you can use those bad facts. And I think we're looking at maybe moving from a 6 to a 7-figure verdict. But again, bad conduct by these departing lawyers, and they got a civil verdict against them. Let me see. I see one question here. Let me see if my eyes are good. Opinions, cases addressing mobility from in-house to private practice or vice versa. You know, not many. And the reason probably is that usually well, let me put it this way. I'm not sure I know all the reasons, but not many is the short answer. But the primary problems involve what's called grabbing and leaving. And of course, if you're moving from in-house outside, that's really not an issue, right? And if you're moving to in-house, usually you're not grabbing a case to take with you when you go into in-house practice. The other thing that is the case, though, and I've seen a couple of cases like this, you can still do terrible stuff when you're leaving a company, like take confidential information and use it. I've seen those. That's a problem. And that's sort of a lawyer mobility problem. Another lawyer mobility problem in the corporate arena is non-competes. Some companies just have not gotten the memo that they cannot put their lawyers under non-competes. But that's the subject for another topic, but another seminar. But the bottom line is, you guys are in-house? Yep, you got the same restrictions on your ability to be bound by non-compete as me in a private firm. Right, let me move on to I think we're at number 9. Yep, number 9, arbitration. And these, when I say arbitration here, I'm talking attorney-client retainer agreements. And so pre-dispute arbitration provisions in attorney-client engagement agreements. We have a case from New Jersey, which is from their Supreme Court, that rejects what otherwise might look as a really nicely drafted, nicely disclosed, nicely obtaining consent to, I'm not saying that right, arbitration agreement in an attorney-client agreement. Supreme Court said, no, we don't think this was good enough. And had you read it without the holding, you might say, well, this looks pretty good. And I think in many jurisdictions, it would quite clearly pass muster. They have imposed a higher standard. So to put this in context, there's several areas of law that touch on this. One is sort of basic consumer protection law or arbitration law, and that applies to lawyers and clients just like everybody else. Then there's ethics, which is really what this case is about, the specific nature of the lawyer-client relationship being a fiduciary relationship, which really does change how contracts work. And then beyond that, there's a question of prudence, and beyond that, there's a question of drafting. So the states, there are a couple of states that are even harsher than New Jersey, where you just can't do them. There are a few states like New Jersey that have a sort of ordinary consumer standard plus, brought about by the fiduciary duty, I think, more than anything else. Then there are a large mass of states where it's permitted, but it is a fiduciary duty, and more important, you have to get informed consent from the client, and you have to discuss risks and benefits with the clients. And specifically, the New Jersey case actually is not a bad place to start if you either see one or need to draft one, an agreement like this, and you want some pointers on what are the risks and benefits. Nice discussion there. Beyond all that, certainly for the people on the attorney end of the spectrum here, now I will say corporate counsel, I'm not sure how many corporate counsel would prefer to have this kind of agreement, although I think there are many who might need to evaluate them. And that's worth doing on each of the grounds I mentioned, namely basic law, outside ethics, these kind of rules, and prudence. You know, the question is it a smart idea to have an arbitration agreement? A couple of factors. Some malpractice carriers hate them. A couple of reasons they hate them are, or I shouldn't put it that way. One of the reasons they hate them is that there's no appeal. Appeal courts sort out a lot of things for insurance companies in malpractice cases. Another is discovery. Discovery is often really valued by defendants in legal malpractice cases. Another factor to consider is confidentiality. Some lawyers want it to be confidential. But in any event, those don't cut just one way. And I would advise any lawyers thinking about this to consult with their carriers, because not all carriers favor them. And more importantly, carriers have some experience, and many of them can provide you really good advice. Final point, drafting. I am not, as many of you know, a corporate lawyer, and most of my partners, kind of like I would, go grab somebody and tackle them if one of our lawyers who did nothing but business work was going to the courthouse. They try to tackle me if I'm doing things like drafting arbitration agreements, but I still do it. But my point being, do not pull the latest AAA form. Do not pull the latest, Practical Law has wonderful forms. We have that. Their latest forms. Now, they could be very good, but use them like any good lawyer uses any good form, which is think through them. Think through all the moving parts and make sure they work for your client. Because from personal experience, I can tell you there's not much worse than having to try an arbitration under a provision that is bad, even if facially it looks okay. All right, conflicts. Before I turn into conflicts, let me see if I've got, let's see. I have a question here. Going back to that Governo case about whether there was a distinction between whether the forms that were stolen were a firm form created by, or whether it was created by the departing attorneys. You put your finger on a really interesting point. Whose work product is it? That has not been much litigated, but that's really almost on the one hand, it's a trade secrets question in some respects, but on the other hand, you can impose a restriction on a departing lawyer that restricts their right to practice. I've never seen a case that actually teed that up squarely, but I certainly think there is some authority to say that if I've developed forms for my practice that I used, my firm is going to have a tough time, even if I've contractually agreed to that that's work product that belongs to the firm. I think they're going to have a tough time keeping me from using it. But again, no good answer to that. And then I don't know the answer to whether there was any disciplinary action against those lawyers. Okay, I'm almost caught up. I'm trying to stay up with the questions. All right, back to conflicts. A couple of quick items on conflicts from the ABA. First is an ABA opinion 494, and this is about personal relationships between opposing counsel. And not just litigation. Remember, it could apply to deal work as well. So who's on the other side of you in a deal? And do you have a personal relationship? And those can give rise to material limitation conflicts. And remember, material limitation conflict is one where my responsibilities to my current client are materially limited. Let me back up a step. I'm actually leaving out a phrase. This is a material limitations conflict is one where there is a significant risk, and that's a big issue, a significant risk that my responsibilities to my client in the matter will be materially limited by my obligations to someone else. Those could be another client, but they also could be another human being, and it could be a personal relationship, not a legal one, not a attorney-client one. So, that's one reason we don't let spouses be on opposite sides of the deal table, probably ever, or at least not without consent, right? Usually it would be well known. But so the first category that the opinion points to is intimate relationships. Not hard to understand why that would be a potential source of a conflict. But the second one is friendships. The third one is acquaintances. They go into a little depth about this and talk about what factors, if the judge, and by the way, this is the same set of categories that the ABA used to address conflicts arising from relationships between judges and lawyers appearing before them on the bench. All right, so judges and lawyers appearing before them. So in that context, if the judge is a fishing buddy of one of the lawyers, is that a problem? It can be, yes, and it can give rise to a conflict, a recusal requirement for judges. And in the other context of lawyers opposing each other, yes, it could give rise to a conflict. But it depends, right? It depends on the facts. This is not hard to visualize, right? The other opinion I've mentioned there is ABA Formal Opinion 497. This actually is of a little more direct relevance to a lot of us because materially adverse is one of those terms that is peppered in a couple of places in the ABA rules, and the model rules present everywhere. So, for example, remember the current client conflict rule says you can't sue your client, right? You can't be directly adverse. That's the term of art to a current client. Well, the former client rule says you can't be materially adverse to a former client. So it's different. This is about what's the difference between those. So everything that's directly adverse certainly would be materially adverse, but materially adverse picks up a lot more. This opinion goes through that. And by the way, the other place that comes up besides former clients is, again, prospective clients. So let's take a look. Let's see what else I've got here. I've got a couple other conflict opinions, but I really want to just mention one. And before we get into that, let me ask, I've got a question. We're going to see how the technology works and how I handle it. I have a poll question for you to answer. Do you regularly use disengagement emails or letters? By which I mean a letter to your client when it's done that says, we're done. Thank you. Engagement's over. And by the way, for in-house counsel, not irrelevant, right? when your attorney-client relation or your company's attorney-client relationship with outside counsel is over, do you regularly use, or do you even regularly see, disengagement letters? Give you a moment to answer. I think we leave. Oh, there we go. Oh, it's like magic. I hope you can see the responses. So so while you're responding to that, I'm going to leave that up for a minute, and we'll see. Maybe we can refresh it or something as we go on. This matters for a number of different reasons. The two most prominent and the two most important probably are disqualification matters and malpractice. And the logic is very simple. We just talked about the difference between current and former clients. If you're the lawyer in that situation, then you really would prefer that your ability to be adverse to that client, you'd prefer to be under the former rule because it is more generous to you than under the current one. On the other hand, if you're the client and you want to keep that lawyer, as your lawyer, even though you don't have a job for him today, but you might tomorrow, and you want to keep him as a current client, think general file, right? Then you don't want that. When they send you a disengagement letter, you might want to write back and say, thanks, but we're not going to do that. We're going to treat you. We want to keep you on retainer, essentially, even informally. And it matters for disqualification purposes, but it also matters for malpractice purposes. Because, of course, if the engagement's over, your duties, fiduciary, otherwise, mostly end. Now you have some duties to former clients. So that matters a lot. This opinion is in fact, we got a number of responses there. So a number of people haven't seen them or used them. This is a tool you need in your toolbox. So just give some thought to this. This case, Dreamfinders, is one where in a disqualification matter, the law firm in question had written a very nice email that as a disengagement email. And the court looked at it, read it, said, yeah, they're a former client at this point, and you can be adverse to them. That actually was to a corporate affiliate. And by the way, I have over the years had some partners who kind of tense up when I tell them they need to do that because, they don't really want to terminate that relationship. They don't want to be rude. Well, then I suggest to you that you think of it as a thank you letter. Don't think of it as a goodbye, we're gone, we're done letter. Doesn't have to be an ugly breakup. It can be a thank you so much for the opportunity to work with you. I really enjoyed it, and I'm looking forward to the next opportunity that we have to work together. Thank you, and have a happy holiday. That can work as a disengagement letter. So don't be afraid of that because it has real value in clearly defining the relationship between lawyer and client. And frankly, I think that's just as important for in-house counsels working for their client in terms of dealing with outside counsel as outside counsel. Number 7 on our list is client confidentiality and Rule 114. Rule 114 is one of the least known rules out there, but it does occasionally come in very handy. You need to know about it. And Rule 114 specifically, well, let me talk about the opinion. That's probably the simplest way in. There's an opinion from Washington. It's in your materials again. And the question is, it arrives in a criminal defense context, but don't be completely put off by that. What can the lawyer representing a criminal defendant appearing in court say when she shows up in court and her client's not there? And TikTok, the client is not there, and the judge finally says, Ms. Smith, where's your client, right? Awkward moment, to put it politely. And the truth is, this opinion walks through, the truth is that what has happened is that the client has been committed civilly to a mental hospital against her will, which, perhaps not a happy day for either lawyer or client, I don't know. But in any event, if the lawyer simply says, oh, well, my client was committed civilly last night to, the big hospital here in town under force, or whatever, involuntarily. Well, that might really not be the best thing in the world to say to the judge for a criminal defendant. On the other hand, it certainly could be the case that not saying that could have bad consequences, certainly in the criminal context, in any context when the client's supposed to be there in court. But, they could have their bond revoked. They could have a bench warrant put out for them. It could just be a really bad thing. So the opinion says, well, yes, this is a dilemma. Well, indeed it is. The opinion also then walks through why that's client confidential information, because all information relating to the representation is, and this kind of information surely would be in virtually every jurisdiction. And so the question is, if you don't have consent from your client up front on whether you can disclose it, there's really no exception to Rule 1.6 on confidentiality that lets you disclose this. And so the question here then is under Rule 114, are you permitted to disclose it? Why Rule 114? Well, it's the rule that deals with clients under a diminished capacity. And what that means is, diminished capacity means if the client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or for some other reason. So think about that. That includes, the 11-year-old child you represent who's perfectly normal and smart, but it can also include the elderly person who may be losing their faculties a little bit, or it could simply be a fully healthy, mentally well or mentally, competent adult, but who's going through a really traumatic situation, because all of us tend to lose some of our capacity in some bad situations, right? The golden rule of Rule 114 is you treat them, no matter their diminished capacity, as a normal client to the greatest extent you possibly can, okay? You may know that the level of capacity needed to form an attorney-client relationship is pretty low compared to the capacity needed for some other things, like informed consent to surgery or something like that. Even that, of course, varies from situation to situation. But the point being that you have to treat them like a regular client as best you can. Now, the key point here, though, is there's a term of art within the rule that authorizes a lawyer to take, and here's a term of art, reasonably necessary protective action, protective of the client, when a lawyer believes that the client has diminished capacity, is at risk of substantial financial, physical, or other harm unless action is taken, and the client can't adequately act in their own interest, right? So the diminished capacity affects their ability to deal with what's before them. And so what would that be? And for example, would it include here the fact that they're under diminished capacity legally? There's a legal finding putting them in the hospital. Could that be enough for reasonably necessary protective action by the lawyer to be disclosing what's really going on to the court? Yes, it could. It certainly could. It's not your first go-to, but it can be. If in the court, the opinion goes on to say, well, even if that's the case, you have to take appropriate steps even then to protect confidential information. So, the court says, the lawyer, where's your client? And the lawyer thinks, for instance, well, judge, here's what happened. But before she does that, she might well say to the judge, my knowledge about that is confidential, and I'd like to be able to approach the bench and discuss this out of the hearing of prosecutor, or maybe come in chambers. That's actually mentioned under Rule 1.6, and that's perfectly appropriate. It might be wise. The other thing that I bring this rule up because it is a really interesting tool that sometimes comes in really handy because of this language. The rule in Tennessee and pretty much everywhere says that reasonably necessary protective action may, in some situations, even include the lawyer, quote, seeking the appointment of a guardian ad litem, conservator, or guardian. Now think about that. Seeking a guardian or conservator for your own client. That sure sounds adverse to me. And I will tell you, the last time this came up for me was with some lawyers who had a client who was clearly in very diminished capacity. And they thought they had reached a really good settlement of a personal injury case. There were, I think, a hospital and a doctor on the other side. And this allowed them to go seek conservatorship. And I mention it because it ain't just interesting and helpful for plaintiffs' lawyers. The defense lawyers in this case that I'm referring to, they wanted, obviously, that to happen because they had reached what they thought was a good settlement. And so they had to understand why these plaintiffs' lawyers were permitted to do what looked like an almost, a traitorous thing against their own client, right, to put them in a conservatorship. So anyway, helpful rule. You don't need it until you really need it, but when you really need it, you really need it, if that makes sense. All right, let's move on. I'm going to see what questions I have missed. I think I'm maybe caught up on questions, maybe. Okay, so has Mr. Green arrived? Years and years ago, I was sitting in Shelby County, one of the Shelby County criminal courts. You might ask, why were you doing that? And I don't rightly remember, except I think it was for a media client. Some of you know I represent media outlets. And so I was waiting my turn because it's, anyway, it's really complicated down there, and I didn't understand what was going on. And so a lawyer stands up in what apparently was a first appearance for a client. When the client's been called up, the lawyer steps up with him and says, Judge, we're going to need another date on this. Mr. Green has not arrived. And there was this titter that went around the audience a little bit. And I was just going, what in the world who's Mr. Green? What's that about? Well, of course, many of you probably know, Mr. Green is money. Mr. Green is, funds to secure the representation. Everybody in the courtroom knew that except me, apparently. And by the way, I will tell you, this is not a Shelby County thing. I was in North Dakota in the last few weeks talking about this topic, and they said, "Oh yeah, that's what we say up here too." Yeah. So apparently that's a universal thing. Anyway, so we're talking here about other people's money, a kind of potpourri here again of topics. First, let me ask you a question first. All right. See if I can get up. There it worked again, like magic. All right. Here's the question: have you or has your client ever used or considered using litigation funding? That's your question. So I want to hear what you guys have to say. And I don't see anybody having answered yet, but get the button out or whatever. And while you're answering, I will talk a little about litigation funding. And I think maybe, yeah, here we go. We got a bunch of responses now. Okay, let's see. Okay, this is not shocking to me. And see if we can let it run just a little bit. But on litigation funding, it's been around probably in this country 30 years or so. There are two spheres, shall we say, of litigation funding, one of which is consumer litigation funding, which may not be as relevant for this audience, but nevertheless, it's where claimants and sometimes their lawyers get litigation funding for the expenses of litigation, sometimes funding for living expenses. There are in many jurisdictions now, if not most American jurisdictions, there's the ability to do that. In the other sphere is commercial litigation funding, where businesses, sometimes individuals, but just as often companies, sometimes they are bet the company claims, maybe a patent claim, maybe a claim for somebody who did great injury to the business, and it is it's a lot of money on the claim. So again, it's commercial and consumer, but it's also claimant and lawyer. So lawyers can get litigation funding as well as their clients, claimants. And there is some talk, I'm not sure I've ever seen one or heard that one really happened, I've not seen one in the wild, of defense side litigation funding, which would work somewhat like a defense side contingent fee, all right? But that's a rare species. I mention all that because there's a new opinion from the California Bar. This is, let's see, this is the state bar. I probably am going to need to change my citations. This is the traditional state bar. And it's a very nice summary of almost all the issues that you get to. It's probably, let's see here, I want to say it's 10 or 20 pages, but for example, it touches on all the issues, almost all the issues that you would care about if you're trying to kind of get your arms around litigation funding. Conflicts, how to avoid conflicts. Let's see, independence. You've got to retain your independence as counsel and your independent professional judgment. It addresses the reverse or obverse or whatever that the funder cannot have control of the litigation, right? And then I think I'm missing something else. Conflicts, independent judgment of the lawyer. Oh yeah, champerty and maintenance. I'm almost tempted. I didn't mention that we may have prizes, but here's one. If somebody can pop in the question Q&A and tell me what to find, champerty or maintenance, your pick, champerty or maintenance. You will get a prize. How's that? Good luck with that, by the way. There are not many people. I'd look at in litigation funding practice. I have a little bit of practice in that area. There are not many people who know what that is, and that's probably fine. Thank you very much. But anybody who does, we have a gift card with your name waiting on it. So I'm waiting. But I'll go on to say that the only issue this article, or excuse me, the ethics opinion does not touch is fee sharing. Oh, and I did leave out one big one, which I'll come back to. Fee sharing. Fee sharing obviously is a problem if you get funding as a lawyer, get funding from a funder and agree to give the funder, 10% of your fee. You can't do that. That is in all states but Arizona. In Arizona, that's now permitted, but we're probably not in Arizona. But otherwise, that's just prohibited. You can't do that. There are ways, however, to do it. For example, one of the traditional ways litigation funding works is that the funder will advance expenses. And then if there's no recovery, there's no requirement to pay back the expenses. There's no requirement to pay a fee. That's why they call it non-recourse. But if there is a recovery, the traditional model would be the lawyer, for example, or the client pays the expenses back plus a multiple of those expenses. And that could be 2 or 3 years down the road. And yes, that sounds high. And yes, that does work out to an imputed interest rate of some consequence. But it nevertheless can be a good business deal for some people. And then the other issue I skipped is probably the most important one, which the opinion talks about a little bit, which is confidential information. So the question is, anybody who's funding a lawsuit needs some information about the lawsuit to fund it. And all you need to know about this subject is right here. The difference in waiver between privilege on the one hand, attorney-client privilege, and work product on the other. On the privilege side, if you share, oh, by the way, one of my minions here in there, or I may be their minions, has reminded me that there are some Adams and Reese folks on this call. We love you dearly, but I don't think we're going to give you the gift card if you can define champerty or maintenance. And by the way, I'm seeing nobody who's even tried to, oh, wait, I see one. Let's see here. First, where a person with no previous interest in a lawsuit financed it in exchange for sharing the disputed property. That is close enough. That is close. Now, let me see if that one, which one of these was first. Oh, my. They were at the same minute, for gosh sakes. But one of them, wait a minute, one of them is a firm lawyer. It's lovely to be partners with someone who knows what champerty is, but I'm sorry, we're not getting you a gift card. But Rebecca Pritchett, gift card with your name on it, headed your way. Thank you for being knowledgeable. And that may not be absolutely perfect, so somebody can quibble with that if they want to, but it's darn close. So champerty and maintenance, you heard it here. All right, back to confidentiality. Privilege waived by disclosing of that privileged information outside of the attorney-client relationship, okay? But work product not. Work product only waived when you do something to make it substantially more likely that that information falls into the hands of your enemy. So in a joint defense agreement, for example, everybody agrees to keep everybody's confidential work product that might be shared confidential. It's like an NDA, like a non-disclosure agreement, which is exactly what you sign with a funder to accomplish the same purpose. You now know almost everything you need to know about litigation funding and client confidentiality. It's a concern. It's a serious one. If you get into this space, these questions, holler. I don't remember. I think I put it in the materials. I've done an article on this that actually touches all 53 or 55 decisions on this, on discovery. I've just been informed. I should remember. Rebecca is with us, for gosh sakes. That's why she's apparently so smart. So, Rebecca, I'm sorry to disappoint your Christmas on that, but still, I got two partners who know what champerty is. All right. So, and let's see. Do I have? All right. Let me ask my minion here. Is the answer to that one at 36 minutes in? That's not one of our folks, is it? Anyway, we may still have a gift card winner, but in any event, sorry about that. All right, so back to where I was. Confidentiality, they touch on confidentiality, and this is a good opinion. That's a good introduction to litigation funding for anybody who needs to look at that at all. By the way, last thing I used to use to give people as a good intro to litigation funding is an ABA white paper from 10 years ago. So it's nice to now have another piece. You can read this and know enough to get started. So in any event, that's a lot on litigation funding. All right, so the New Hampshire opinion. What do you do with uncashed trust account checks? This should be an easy question. I'm not even gonna. Oh yes, I'm sorry. That is correct. We did get a winner. We did get a winner, and that is Julie Forum. I may be mispronouncing your name. I apologize for that, but you got a gift card anyway, even if I screwed up your name. So thank you again for being a smart person about champerty and maintenance. All right. New Hampshire. What do you do with uncashed trust account check? And the notion is you closed a deal in July, and you discover that a couple of the checks have not been cashed. What do? Do you declare a dividend and take that money and go have a nice lunch? No, of course not. That's whoever the payee is, it's their money. And remarkably, there are people who will not cash trust checks for all kinds of reasons. Usually it's either sloth or laziness, or these days it might well be the U.S. Postal Service. God bless them. But in any event, whatever the cause, that is not the lawyer's money. Efforts need to be made by the lawyer to get that money to the right person. It needs to be a part of the normal monthly reconciliation and balancing of a trust account. And then efforts need to be made to get it to them. And by the way, that includes searching for the person. And then, by the way, every state has what used to be called escheat law, E-S-C-H-E-A-T, that now it's usually the Unclaimed Property Disposition Act or some version of it. And you have to then, if after a long enough period passes as set by statute, you can't find the person and they don't claim the money, you got to turn it over to the state. So this is not for the faint of heart, and whoever does your trust account reconciliation certainly needs to know this. Final item on other people's money. Can you use Venmo or PayPal or similar services for client payments? And client payments to lawyers? And the answer to that is yes, but you need to have your wits about you. You need to think about confidentiality and commingling. And in fact, we crossed that bridge, so to speak, and figured that out with respect to credit cards, debit cards, and ACH, bank-to-bank transfers, right? We figured that out on those. In fact, there's at least one service, LawPay, that will do that for you. It's a service they sell to lawyers and makes you able to collect those funds from clients in an appropriate, ethical way. But Venmo is not something that those services use. In fact, I'm not sure I understood Venmo at all until my 20-something sons explained it to me. Hopefully some of you know how it works, but the bottom line is it's a way for people to peer-to-peer share funds. You put some money sort of in a Venmo account, and then you can share that money across Venmo. You go have a pizza with 5 of your friends, one of them picks up the tab. You can Venmo to the person paying the tab on their credit card, can Venmo your share to them, okay? Only problem with this from a lawyer point of view is, well, two, confidentiality and commingling. And this is what the opinion says. You have to maintain confidentiality. Venmo, when it started, the default was that it would show up to all of my friends as a sort of social media post on Venmo that I'd either paid for the pizza maybe on Venmo, I could do that conceivably, or shared money for a pizza with somebody. So, you know, the notion that I go hire a DUI lawyer and pay him $1,000 and that shows up to all my friends, yeah, that's a client confidentiality issue. So you have to have your wits about you when you do that, but it is certainly possible. The other thing I will share with you, if you haven't seen the Clio legal trends report that they have done several times now. Clio is a big legal case management software company with access to lots and lots of data from practices, mostly of lawyers sort of smaller than big law firms, whether it's a solo or a 10-lawyer firm or bigger. And here's what they found from their data. And this, I think, might be relevant to everybody, that, you know, because even those of you in-house, your clients have, as they call it, a legal spend. And so here's the question. Posit two sets of lawyers. They've teased this out from the data. One set of lawyers who do not use anything electronic to take care of three things: client intake, sharing documents like an online portal, or payment from clients. And then there's another group of firms that they have in their database who use all three. The difference is the firms that use all three, they have $40,000 per lawyer per year greater revenue than the folks who do not do any of those three things electronically. In case you're wondering, that means, among other things, clients like to pay electronically. Well, duh. Even though we are slow adopters, now we've been hit over the head with this. And frankly, if you're an in-house lawyer and you hire any lawyers at all outside, I'd be willing to bet you that your CFO or your accounts payable people, if you do not subscribe to some service that allows electronic payment and tracking, they might actually like that if that went paperless. And it might be a win-win, as they say, both for the company and for its outside counsel. So actual data from the field on that one. All right, negative online reviews. You know, we're moving pretty far up the list here. And I will say this, and not much more about negative online reviews. The truth is that lawyers have done stupid things forever. Lawyers will certainly continue to do stupid things. This is sort of a new kind of stupid thing because it amplifies what you might say, you know, in a offhand comment in a bar with your colleague lawyers to be around the world. So the concept here is that the lawyer whose practice depends on online reviews gets a bad one and gets very upset and goes to the keyboard and types things about the client that are unflattering and that are also client confidential information, something about their criminal record or something like that. That's a problem because we cannot disclose client confidential information without consent except in very limited circumstances. One of the circumstances is to collect a fee, to defend a malpractice case. And some lawyers have this notion that, well, this is the same kind of thing. almost all the opinions out there say it's not the same kind of thing. And so lawyers can get in trouble pretty quickly by saying almost anything, not anything confidential in response to a negative online review. That ABA opinion is a nice treatment of that. I have an article I put in there that I did. And then there's one sort of outlier case from this year that suggests that there may be client confidential information you can use. My response to which is don't do it. It's just too risky. But further, in the article, I talk through some of the things that you might want to say. And by the way, this is again something that in-house counsel, I will tell you, I'm certainly aware of situations where in-house lawyers have had similar, what amount to bad reviews against them by people they've dealt with for the company. And the same advice applies. The same, even though you're across the V from them, be very, very careful of this because lawyers are routinely getting in trouble for this sort of thing these days. We have now the ethics case of the year from right here in Tennessee. I'm not sure that should be a source of pride. You can be the judge in a moment. Specifically, there was an exchange of Facebook messages between a lawyer and someone who was not the lawyer's client. And it led to our Supreme Court issuing an opinion holding this lawyer suspended for 4 years, with 2 of those years on active suspension. Specifically, this lawyer, and in a moment I'm going to show you some of the posts, this lawyer was a Facebook friend of this woman, Lauren Houston. They hadn't met in person, but in 2017, Ms. Houston was in the midst of a tumultuous breakup with the father of her child, one Jason Henderson. And through Mr. Sitton's Facebook connection with her, he became aware of really an unpleasant history that she had with this fellow, including allegations of abuse and harassment and violations of child custody arrangements and requests for orders of protection. So one day, Ms. Houston wrote, and this is from the file, from the actual court file. This is what she wrote on her Facebook page. I need to always carry my gun with me now, don't I? Is it legal to carry in Tennessee in your car without paying the damn state? Now, as anybody who uses Facebook knows, that was not posted to anybody in specific, but to all of her Facebook friends and probably others. And specifically responding to that post, Mr. Sitton, the lawyer, says, and by the way, this too is visible. I have a carry permit, Lauren. The problem is that if you pull your gun, you must use it. I'm afraid that with your volatile relationship with your baby's daddy, you will kill your ex, your son's father. Better to get a taser or canister of tear gas. Effective but not deadly. If you get a shotgun, fill the first couple of rounds with rock salt, the second couple with birdshot, and then load for bear. If you want to kill him, then lure him into your house and claim he broke in with the intent to do you bodily harm and that you feared for your life. Even with the new standard ground law, the Castle Doctrine is a far safer basis for use of deadly force. And in response, Ms. Houston said, I wish he would try. Now, in further response, Mr. Sitton posted the following. As a lawyer, I advise you to keep mum about this if you're remotely serious. Delete this thread and keep quiet. Your defense is that you are afraid for your life. Revenge or premeditation of any sort will be used against you at trial. Now, bear in mind, every bit of this was visible, not only to Sitton and Houston, but other Facebook users. And so another Facebook user commented, I think I can see it on the screen there. Maybe I've gone past it. No, yeah, there it is. I'm sorry. He's likely already seen this thread. Yes, indeed. He had. Ms. Houston did, in fact, delete the post on Sitton's advice. And then the target, so to speak, Mr. Henderson, actually took this information to the Shelby County District Attorney General and Ms. Amy Wyrick, who in turn passed the screenshots along to the Board of Professional Responsibility. Suffice it to say that our disciplinary system did not deal kindly. The hearing panel at the first level gave him a 60-day suspension, and nobody appealed. But those kind of orders have to be approved by our Supreme Court, which looked at that and said, no, that is not enough, and put it down for further argument and upped the active suspension to 2 years and the full suspension to 4. They pointed out, he pointed out that, it was taken out of context. And really, the comments about the Castle Doctrine, they were just sarcasm and dark humor. And I really wanted to try to get her not to use her gun. Okay, well, the Supreme Court didn't buy any of that at all. Further, he commented that, well, look, what person in their right mind, not in these words, would say all this stuff as a lawyer to somebody publicly? Surely that's evidence it wasn't sarcastic. It was sarcastic, right? Supreme Court said, no, we don't think so. It was public. that's worse. That's an aggravating factor. And in fact, what they basically concluded was that he had offered specific legal advice on how to orchestrate a killing in a way calculated to provide the perpetrator with a fabricated defense to criminal charges. And then in an ultimately unsuccessful, they say, effort to conceal the conversation, he directed her to delete the comment thread. Our rules do not permit lawyers to offer advice on how to commit crimes with impunity. Mr. Sitton is suspended for 2 years. All right, let's move on to lawyer impairment. You know, this is a continuing problem that we lawyers have. And specifically, you may recall several years ago in 2016 that there was this huge study of something like 16,000 lawyers in a number of states, including Tennessee, and something like 12 other states, as I recall. And it's the biggest study that had ever been done, and it revealed not only what we all knew, that mental health and substance abuse issues were very serious. You see some of the numbers there. By the way, those numbers are not about people who, for example, are kind of depressed and not having a bad day and having a bad day. This is about people with serious clinical depression. That's 28% of the lawyers in this country. Drinkers, again, problem drinkers, clinically diagnosed. Okay, serious stuff. These numbers are 3 times as high as for non-lawyers, ordinary Americans. They are higher than any other profession. So they were an alarm bell in a number of respects. And here is the most troubling statistic. And this took everybody, was shocked, the clinicians, the disciplinary people, and that is the people most at risk in our profession for mental health and substance abuse problems are younger lawyers. They're lawyers in their first 10 years of practice. That totally blew the minds of all those of us who had any way to touch these issues. I'm no expert on this subject, but I do disciplinary matters. And so I know I was shocked. Every disciplinary lawyer in the country was. Every lawyer assistance person in the country was. But it is a tonic. Tonic is not the right word. It is an alarm to remind us that as we are, in fact, our brothers and sisters' keeper, we don't need to dismiss concerns that we have about young lawyers simply because they're young, whether we think it's part of the culture of being young to drink too much or to whatever it is, where we might not forgive as readily somebody 20 years in practice. We might need to flip that. We might need to be more concerned and more willing to reach out. On top of all that is the pandemic. Question for you, serious question for you. You know a lawyer who's had mental health effects from the pandemic? Simple question. I think the evidence is there is a lot of depression, there's a lot of anxiety arising from the pandemic. Interestingly, the lawyer assistance people say for the better part of a year into the pandemic, they did not get increased calls. They think it was because people were, in some sense, hunkered down at home, and those problems were not as visible. There we go. It's certainly not inconsistent with my experience. A lot of us know and have seen lawyers, and may be lawyers, who have had these kind of issues, particularly during the pandemic. It's a reason that we need to be more sensitive to our brothers and sisters and do what we can to help them. Let's see. Let me look for other questions. I note some of these comments, and you can certainly note those yourself. Let's see. Let me move on just a little bit further on this subject, and that is real simple. There's a new opinion, which I pointed to on this, but the lawyer assistance people in your jurisdiction, no matter where you are to a person uniquely qualified in ways that most lawyers do not understand, literally do not understand. I used to say that lawyer assistance is like magic because they know things clinically, they know what to do to help us. So if you're having a problem, if some lawyer you know is having a problem, find the name, the number of the lawyer assistance people in your state and get some help. And by the way, even if it is simply the fact that you're worried that your partner or your associate or your paralegal is having some trouble, they're behaving in a different way, even if you're not sure they're having a problem, one thing you can do besides talk to your colleagues in your office, you can call lawyer assistance. I've done this and say, okay, here's what I'm observing. Should I be worried? Now, they will not be able to sort of tell you whether they've gotten other reports on this person, but they will be able to tell you, number one, whether those are symptoms that might be worthy of concern. They'll also then have tools to tell you where you might be able to do something to help someone. And of course, they are who that person you're worried about might be sent, might go to get help. Two last topics. One is, where's Waldo's attorney remote work? we've had a sea change in the way that remote work has been treated by our ethics rules. For years, we ethics lawyers were concerned about whether if I, as a Tennessee lawyer, and many of you know that I'm just not very far from both Arkansas and Mississippi, if I decided to not come to the office anymore, but move over to a lake in Arkansas and continue practicing from there, we ethics lawyers were a little worried about that if I wasn't licensed in Arkansas. And the way we expressed it was it's a butt in seat problem. And that is to say, Arkansas might take the position, well, Mr. Pera's butt is in a seat in Arkansas and he's practicing law, and that's a problem. He ain't authorized to practice law. A series of opinions, and here they are, from the ABA and elsewhere, have said, no, that is not a problem. As long as you, and there's several considerations there. One, don't hold out to be an Arkansas lawyer. Two, don't advise on Arkansas law. Three, don't handle Arkansas matters. Four, don't, what did I forget? Don't advise, don't handle Arkansas law matters, I've forgotten something. I can't remember what it is. Let me walk through them again. Maybe it'll come back to me. You can't hold out as an Arkansas lawyer. You can't handle an Arkansas law, advice matter. You can't represent Arkansas clients. I think that's it. But you have to stay in a zone where you are not practicing law in Arkansas. That's a sea change. And again, I think I'll leave that, since we're running short on time, I'm leaving that to your reading, but that has changed a lot about how we think about remote practice, let's say. And by the way, if you're in-house and you have not had this experience, you will. Because in the same way that law firms are hiring lawyers who are licensed in places other than where they live, and maybe they keep them virtual, all right, and don't give them an office, that is potentially quite permissible. The same is true for corporate counsel. They can be, living and working in Wichita, but licensed in Illinois and have their company client be in Illinois. So there are solutions here to problems we did not know existed 2 years ago. Are you still watching? Some states require us to make sure that you are awake and alert, or at least watching. So respond there if you would. I'm going to see if I can move on. Finally, cybersecurity. It has been on my top 10 list at the top for quite some time now. I'm not sure that's a good thing, but we're doing better. There's an ABA opinion I point to, and it's in the materials on virtual practice, that covers a whole raft of issues that come up, a tour of the horizon of when you're practicing in a way that you're not, as I'm doing these days, coming to an office, right? You're working from home. What do you have to be aware of? And there are a whole half a dozen of them at least. And this opinion walks through all of them, not at a superficial level, but at a higher level. Okay, so it's a very nice summary. Other opinions I've listed there do similar work, and they're really been a good series of opinions that have come out during the pandemic. I will say, however, there's good news. And the good news is that there has been very, very little bad news to report about how lawyers have handled cybersecurity when working remotely. So we don't have a parade of horror stories. There are two related reasons for that, I think. One is lawyers have been really conscious, and these opinions came out in a time frame where they were able to read them and think about them, and they've paid attention to the fact that they're on a confidential call or a video call with a client or whatever, and they've paid attention to the fact that their child or their spouse or someone else is 20 feet away with the door open. They've learned to close the door, right? Or find a different workspace or something really confidential. The other reason is that many lawyers have essentially outsourced their security, and by which I mean one of the big moves has been for lawyers to take up cloud-based computing. So moving from Outlook and Office, Microsoft products that sit on your desktop and maybe on a server at your company or with your law firm, to instead move to Office 365 or Microsoft 365. They seem to change the names frequently. The notion there being that all your data is on a server that Microsoft operates, and a very thin client essentially is sitting on your machine, and your data and all is protected by Microsoft off in some much safer place. And frankly, it may not have always been true, but it is true now. Microsoft is clearly smarter than almost any law firm in the world about these things. And so outsourcing security has worked for lawyers. So on the slide, I mentioned a trickle, and it is a trickle of lawsuits that arise from cybersecurity claims against lawyers just but very, very few of them. They do happen. Ransomware, however, is a constant battle. And especially in the holiday season, bad guys have been using our holiday spirit against us and finding new ways to try to trick us and get our credentials or hack our accounts. So increased vigilance is always needed. And then the next to final thing I think I want to mention, defense counsel or outside counsel guidelines rather, and questionnaires and audits. You know, this has been a roiling kind of irritant between lawyers and especially corporate clients. I love you guys, really I do, the in-house folks who are on this call, so many of you. But sometimes your clients can be difficult about outside counsel guidelines. And over the last several years, cybersecurity concerns have driven a lot of that. We're going to have to find a way through that. Right now, it's very difficult for both of us in the sense that we've got to go through lots of effort to prove compliance. But I also know, for example, your companies have got to dispatch people to look at them and figure out what their standards are. We're going to have to get to a solution there. We are not there yet. I would simply suggest, particularly to corporate counsel, a little caution about how onerous you want those to be, particularly when you're first adopting. There's still some people first adopting. I'm over a little bit, I know. Bear with me for another minute or so. Answer this question. Do you use a password manager? And while you're answering it, let me tell you, I've dealt with technology, lawyer technology, as much as any of you over the years. Best two purchases of my life as far as technology. This is one of them, right? A headset that is wired, because I'm not, turning my neck in all contortions. But the other one is a password manager. For those of you who don't know, a password, all right, there we go. We got some no's there. Listen up, people. For certainly less than $100 a year, probably much less than $100 a year, you can have a service that will, on all your devices, let you keep one password in mind, all right, and remember that one. And that unlocks this trove of all your other 250 passwords for everything from Pacer to your Wall Street Journal subscription to your, your New York Times cooking subscription, whatever. Everything can be in there. And they keep it secure. And they will populate it across your devices. And yes, it is secure. I recommend it as a mental health imperative. And then finally, this is really final. I know I'm running over, but I just frankly really want to get to this. I suggest for your reading these two articles. One of them is Shamelessly Mine. Here's the simple principle. It's a part of lawyer competence to know how to use the technology we need to use and want to use and our clients want us to use to practice law. Okay, that means we got to know how to use it. We got to learn how to use it. But I submit it's more than simply learning how to use Office 365 when you subscribe. It is a constant battle. And my suggestion is you need to read the news to know what's going on in the world these days, okay, so that you can protect yourself and your clients. That's the premise of the article. One example, the Microsoft hack that occurred in early 2021. It was the result of Exchange servers being hacked. So if my law firm has its own servers that run Exchange, which powers Outlook, then that was at risk, all right? So, and by the way, DOJ had like 3,500 email accounts that were hacked. Like, that's a bad day for anybody. All right. So the two questions you need to ask when you see something like that, you ask your tech guru, you say, number one, am I safe or am I at risk? And number two, what can I learn from this? That example, well, you're safe if you're on Office 365 because Microsoft patched it at the same time they announced it to the whole world. And so that way, outsourcing security protected you. If you've got an Exchange server and your tech guru had said, well, no, I guess we got to patch the Exchange server, you need a new tech guru, all right? And then what can you learn from that? Cloud computing is sometimes safer. Well, in response to that article, my dear friend from North Carolina, Catherine Reach, wrote her own article. She said, yes, I agree with that. And then she said, here's how you can stay up to speed on security. And she pointed to a bunch of resources. Her own blog is among them, I think. But here's some sources you can subscribe to. Some of them are a little wonky, a little techy, but I simply submit, pick one, follow it for a while. You won't read everything, but it's a way to keep more up to date. I apologize for going over, but the last couple of things I thought were really important. So with that, let me thank the the Adams and Reese team that helped put this together, ranging from, I'm going to miss somebody, Laura Sillers and Jimmy Bilbo and Kat Philippi and Leslie Norman. None of this happens just from me. I can bloody well assure you of that. Thank you for being with us. I will try to answer any questions that are not there, and we will get that gift card out to our one winner. And thank you, and happy holidays. Take care, everybody.